They didn't just change my father's will. They erased me from it, and waited until he was dead to tell me. I found out in a lawyer's office, sitting beside the woman who had replaced my mother, listening as my father's life was redistributed like inventory. The house went to her. The retirement accounts went to her. The insurance. The investments. Everything. My name surfaced once, briefly, like a clerical afterthought. A truck. $12,000. A relic. Not an inheritance, an insult. I didn't need to look at Diane to know she wasn't surprised. She was calm in the way people are when they've already won. This wasn't grief. This was confirmation. Somewhere before my father's heart stopped, while he was lonely and declining and dependent, someone had rewritten his final wishes to make me irrelevant. The lawyer read the date and the timeline snapped into focus. 18 months earlier. After my mother died. After Diane became indispensable. After she became the filter between my father and the rest of the world. That was the moment I understood this wasn't about generosity or love or clarity. It was about access. Control. Timing. My father hadn't believed in extremes, he believed in balance, in protecting everyone without destroying anyone. This document didn't sound like him. It sounded like someone speaking for him. Someone who knew exactly when to ask and when to keep him isolated. Diane thought the paper did the work for her. That the newest signature overrode every intention that came before it. That proximity beat history. What she didn't know, what she never bothered to check, was that my father had planned for this exact scenario years earlier, when his mind was sharp and his judgment intact. He'd left behind a safeguard. One condition buried inside the original will. A clause designed to invalidate any rewrite made under influence or confusion. As the lawyer closed the file, Diane believed the story was finished. She believed possession meant permanence. She believed I was boxed out forever. She was wrong. Because the will she thought gave her everything had already failed one test. And the thing she overlooked, the one thing my father never forgot, was about to tear the entire document apart. I drove home in silence. Pulled into my driveway. Sat in the car staring at nothing. 18 months ago, my father had called me. Said he was updating his estate plan. Said Diane thought it made sense to simplify things. That leaving everything to her was cleaner. That she'd make sure I was taken care of. He'd asked what I thought. I'd said if that's what he wanted, I trusted him. I'd meant it. I'd believed him when he said Diane would take care of me. That this was just paperwork. That the real inheritance was the relationship we had, the memories, the time we'd spent together. Now, sitting in my driveway, I realized what had actually happened. Diane hadn't suggested simplifying. She'd orchestrated a complete transfer. And my father, grieving, lonely, dependent on her for companionship and care, had signed without fully understanding what he was giving away. Not just money. But the security he'd spent 40 years building for his family. For me. I pulled out my phone. Scrolled back through old messages. Found the conversation from 2 years ago. Before my mother died. Before Diane. My father had texted me a photo of a document. His estate plan. He'd wanted me to review it. Make sure I understood everything. I'd saved it. Never thought I'd need it. But there it was. A will dated 3 years prior. And in that version, the distribution was completely different. The original will split the estate. Diane would receive the house, half the retirement accounts, and enough to live comfortably. I would receive the other half of the retirement accounts, the life insurance, and the investment portfolio. It wasn't 50-50. But it was fair. It reflected the reality that Diane had been in his life for 5 years while I'd been his daughter for 32. That he wanted to provide for her without erasing me. I took screenshots of the old will. Compared it line by line to the new one. The differences were stark. The original had been written by an attorney. Detailed. Specific. Clear reasoning for each distribution. The new will was simpler. Shorter. Written in language that sounded like it had been drafted quickly. And critically, it had been signed at a different law firm. Not Mr. Richardson's office, where my father had worked for 20 years. A new attorney. One I'd never heard of. Located 40 miles from where my father lived. That detail stuck with me. Why would my father drive 40 miles to a new attorney when he trusted Mr. Richardson for decades? Unless someone had suggested it. Someone who didn't want the original attorney asking questions. I called Mr. Richardson. Asked if he'd been aware my father had rewritten his will elsewhere. He paused. Said no. Said he'd assumed he was still my father's attorney of record. Said it was unusual for a client to switch without explanation. I asked if he still had the original will on file. He said yes. I asked if I could get a copy. He said he'd send it over. Let me tell you who we were. My name is Rebecca Caldwell. I'm 32 years old. I work in healthcare administration. I grew up in a middle-class family. My father, Thomas, was an engineer. My mother, Anne, was a teacher. They'd been married for 35 years when she died of cancer 3 years ago. The grief nearly destroyed my father. He'd lost weight. Stopped going out. Spent days alone in the house they'd shared. I'd visited as often as I could. Called daily. Tried to pull him out of the darkness. But I lived 2 hours away. Had a demanding job. Couldn't be there every day. That's when Diane appeared. She was a widow. Had lost her husband 2 years prior. They'd met at a grief support group. She understood what he was going through in ways I couldn't. She'd been kind at first. Called to check on him. Brought meals. Sat with him during the worst days. I'd been grateful. Relieved, even. That he wasn't alone. They'd started dating 6 months after my mother died. Married a year later. I'd supported it. Told myself my father deserved companionship. That my mother would have wanted him to be happy. That Diane seemed to genuinely care about him. Now I understood differently. Diane hadn't been offering companionship. She'd been positioning herself. And I'd been too trusting, too focused on my father's emotional well-being, to see the financial maneuvering happening underneath. I hired a probate attorney 3 days after the will reading. Her name was Michelle Torres. She specialized in contested estates. I walked her through everything. The original will. The new will. The timeline showing when Diane entered the picture and when the will changed. The fact that my father had switched attorneys without telling anyone. Michelle reviewed both documents carefully. Then she asked a question that changed everything. Did your father have capacity when he signed the new will? I said I didn't know. He'd seemed fine. Sad. Grieving. But functional. She said grief can impair judgment. That courts recognize diminished capacity isn't just about dementia or medical diagnosis. It's about whether someone fully understood what they were signing. Whether they were under undue influence. I asked what undue influence meant. She explained. It's when someone in a position of trust uses that position to manipulate a vulnerable person's decisions for their own benefit. Isolation. Controlling information. Making decisions during periods of emotional weakness. I thought about the timeline. My mother had died. My father had spiraled into depression. Diane had appeared. Become his primary support system. Married him. Then convinced him to rewrite his will. With a new attorney. Without telling me. Without telling his longtime lawyer. Michelle said we had grounds to challenge. But we'd need evidence. Evidence that my father didn't fully understand what he was signing. Or evidence that Diane had manipulated the process. I started documenting everything. Not emotionally. Methodically. I pulled my father's medical records from the year before he died. With permission from his primary care physician, who'd known our family for decades. The records showed something I hadn't known. My father had been diagnosed with early-stage cognitive decline 8 months before the new will was signed. Not dementia. Not Alzheimer's. But measurable decline in executive function and decision-making capacity. His doctor had recommended follow-up evaluations. Cognitive testing. Possible medication. My father had agreed during the appointment. But he'd never followed up. Never scheduled the tests. Never filled the prescriptions. I called his doctor. Asked why the follow-up hadn't happened. He said my father had called to cancel. Said his wife thought it wasn't necessary. That she'd monitor him at home. The doctor had documented the conversation. Noted that the decision concerned him. Recommended that family members be involved in care decisions. But my father had insisted. Said Diane had it handled. I asked when this conversation had taken place. The doctor checked his notes. 6 months before the new will was signed. 2 months before my father switched attorneys. The timeline was becoming clear. Diane had known about the cognitive decline. Had prevented proper evaluation. Had isolated my father from medical oversight. And then had guided him to rewrite his will. All while his judgment was compromised. I didn't confront Diane. Not yet. Because confrontation would alert her that I was building a case. Instead, I focused on the will itself. Specifically, the law firm that had drafted it. I contacted them. Explained that I was my father's daughter. That I had questions about the circumstances under which the will had been executed. They were polite but guarded. Said attorney-client privilege prevented them from discussing details. I asked if they'd conducted a capacity evaluation before drafting the will. They said it wasn't standard practice unless there were obvious signs of impairment. I asked if they'd been aware of my father's cognitive decline diagnosis. They said no. That information hadn't been disclosed. I asked if anyone else had been present during the drafting and signing. They hesitated. Then said that my father's wife had been present for the initial consultation. That she'd provided background information about the family situation. That she'd helped clarify my father's wishes when he seemed uncertain about details. That confirmation was critical. Because it meant Diane hadn't just influenced my father at home. She'd been in the room when the will was drafted. Providing her version of what he wanted. Clarifying when he was confused. Shaping the document in real time. Michelle said that was evidence of undue influence. That if my father's cognitive decline made him uncertain, and Diane was there to guide every decision, the will might not reflect his actual intentions. It might reflect what Diane wanted him to intend. Then I found the clause. The forgotten thing that would change everything. I was reviewing the original will, the one from 3 years ago, when I noticed language I'd overlooked before. A specific provision buried in the middle of the document. It said that any subsequent wills would be invalid unless they were executed in the presence of 2 independent witnesses who could attest to the testator's capacity and freedom from undue influence. And those witnesses couldn't be beneficiaries or relatives of beneficiaries. It was a standard protection clause. Something my father's original attorney had included to prevent exactly what had happened. Someone manipulating him into changing his will without oversight. I checked the new will. The one that gave everything to Diane. It had been witnessed. But the witnesses were employees of the law firm that drafted it. Not independent. They hadn't evaluated my father's capacity. They just watched him sign. And critically, one of the witnesses was the paralegal who'd helped Diane schedule the appointment and prepare the paperwork. The new will didn't meet the requirements of the protection clause. Which meant, legally, it might be invalid. The original will might still control. I called Michelle immediately. Sent her the language. She read it carefully. Then she said something that made my hands shake. This changes everything. If the new will doesn't satisfy the requirements of the protection clause, it's void. The prior will controls. And under that will, you inherit half the estate. Michelle filed the will contest 3 weeks after my father's death. The petition was straightforward. It argued that the new will was invalid for 2 reasons. First, it didn't comply with the protection clause in the original will requiring independent witnesses who could attest to capacity and freedom from undue influence. Second, it had been executed when my father lacked capacity due to documented cognitive decline and was under the undue influence of his spouse, who'd been present during drafting and had prevented proper medical evaluation. We attached the original will showing the protection clause. Medical records showing the cognitive decline diagnosis. The doctor's notes about the cancelled follow-up and Diane's intervention. The law firm's confirmation that Diane had been present during drafting. And witness statements from friends who'd noticed my father becoming more dependent on Diane and more isolated from others in the months before the will was signed. Diane's attorney responded within days. The response was aggressive. Said the contest was baseless. That my father had been of sound mind. That he'd made his wishes clear. That I was motivated by greed, not concern for his actual intentions. They argued that the protection clause didn't apply to subsequent wills. That it was just advisory language. That the witnesses at the new law firm were sufficient. But they couldn't explain why my father had switched attorneys. Why he'd never mentioned the new will to anyone. Why Diane had prevented medical follow-up that might have documented his capacity issues. The gaps in their story were growing. Discovery was brutal. Both sides had to produce documents. Medical records. Financial statements. Communications. Everything. I turned over the original will, medical records, and witness statements. Diane's side produced the new will and affidavits from the law firm staff saying my father had seemed fine during the signing. But they couldn't produce evidence of capacity. Because there hadn't been an evaluation. The law firm had simply assumed he was competent. And that assumption, Michelle explained, wasn't enough when there was evidence suggesting otherwise. Then we deposed the attorney who drafted the new will. A lawyer named Roger Webb who'd been practicing for 15 years. Michelle asked him directly. Were you aware that Mr. Caldwell had been diagnosed with cognitive decline? He said no. That hadn't been disclosed. Did you conduct any independent evaluation of his capacity before drafting the will? He said no. That wasn't their standard practice. Was anyone else present during the consultation and drafting? He said yes. Mrs. Caldwell had been there. Did she participate in explaining what Mr. Caldwell wanted? He hesitated. Then said yes. When Mr. Caldwell seemed uncertain about details, she'd helped clarify. Can you give an example? He described a moment when my father couldn't remember the exact value of his retirement accounts. Diane had provided the numbers. Another moment when he'd asked if I should receive something. Diane had said I'd already been provided for through other means. The attorney had relied on her representations. Hadn't verified them. Hadn't asked to speak to my father alone. The deposition made it clear. My father hadn't drafted that will. Diane had. With him sitting there, confused and compliant, while she shaped every provision. The protection clause became the center of the case. Diane's attorney argued it was just precautionary language. That it didn't actually require independent capacity evaluations for future wills. That it was standard boilerplate that didn't create binding requirements. Michelle countered with case law. Showed examples of courts enforcing similar clauses. Explained that the language wasn't boilerplate. It was specific. Intentional. My father's original attorney had included it precisely because my father was concerned about being manipulated as he aged. The original attorney was still alive. Still practicing. Michelle called him as a witness. Asked him directly. Why did you include the protection clause in Mr. Caldwell's will? He said because Mr. Caldwell had asked for it. That my father had been worried about cognitive decline. Had seen what happened to his own father, who developed dementia and been taken advantage of financially. Had wanted safeguards. Had specifically requested language that would require independent verification if he ever tried to change the will. Did Mr. Caldwell understand what that clause meant? Yes. He'd insisted on it. The testimony was devastating to Diane's case. Because it proved the clause wasn't random. It was intentional protection. And the new will had ignored it completely. Diane's attorney tried to recover. Asked if my father could have simply changed his mind. The attorney said yes. But he would have needed to explicitly revoke the protection clause. Which he hadn't done. The new will made no mention of the clause. Didn't acknowledge it. Didn't revoke it. Just ignored it. And that omission was fatal. 3 months into the litigation, Diane's attorney reached out about settlement. They proposed a compromise. Diane would keep the house and her half of the retirement accounts as specified in the original will. I would receive my half of the retirement accounts, the life insurance, and the investment portfolio. Exactly as the original will had outlined. In exchange, we both agreed to drop all claims and sign mutual releases. I read the proposal twice. It was exactly what the original will said. Word for word. They were offering to implement the document they'd spent months claiming was superseded. Michelle said it was an admission. They knew the protection clause would hold up in court. That the new will would be declared invalid. That they'd lose completely if we went to trial. So they were trying to settle on terms that made it look like compromise when it was actually capitulation. I told Michelle to reject it. She asked why. I said because settlement implied both sides had legitimate claims. That this was a negotiation between equals. But it wasn't. The new will was invalid. Diane had manipulated my father during cognitive decline. Had prevented medical evaluation. Had been in the room shaping a document he couldn't fully understand. That wasn't a legitimate claim. That was elder abuse. And I wanted a judgment saying so. Michelle warned me. Trials are expensive. Emotionally draining. Even if we win, it takes time. But I wasn't interested in speed. I was interested in truth. In a legal finding that what Diane had done was wrong. That my father's intentions, his real intentions from when he had capacity, would be honored. The trial took 4 days. My attorney presented the original will with the protection clause. The medical records showing cognitive decline. The doctor's testimony about cancelled follow-up and Diane's intervention. The original attorney's testimony about why the clause was included. And expert testimony from a geriatric psychiatrist about how cognitive decline affects judgment and makes people vulnerable to undue influence. Diane's side tried to argue that my father had been fine. That he'd wanted to provide for his wife. That the new will reflected his genuine wishes. But they couldn't explain the protection clause. Couldn't explain why he'd switched attorneys. Couldn't explain why Diane had been in the room during drafting. Couldn't produce any evidence that he'd had capacity beyond the assumption of the attorney who drafted the document. The judge asked pointed questions. Why wasn't the protection clause mentioned in the new will? Diane's attorney said they weren't aware of it. The judge asked how an attorney could draft a new will without reviewing the prior will to see what provisions existed. No good answer. Why wasn't Mr. Caldwell evaluated for capacity given the medical diagnosis of cognitive decline? Diane's attorney said the diagnosis was mild. The judge asked if mild decline was enough to make someone vulnerable to influence. The expert witness said yes. Absolutely. Why was Mrs. Caldwell present during the drafting and signing? Diane's attorney said she was his wife. The judge asked if that was appropriate when she was the primary beneficiary. Silence. The gaps were too large. The explanations too weak. And the protection clause was too clear. The judge issued his ruling 2 weeks later. The decision was procedural, clinical, unemotional. The court found that the original will contained a valid protection clause requiring independent witnesses who could attest to capacity and freedom from undue influence for any subsequent wills. The new will did not satisfy these requirements. Therefore, the new will was invalid. The original will would control distribution of the estate. Additionally, the court found evidence of undue influence. Mr. Caldwell had documented cognitive decline. Mrs. Caldwell had prevented medical follow-up. She had been present during drafting of a will that disproportionately benefited her. And she had failed to disclose the cognitive decline to the attorney drafting the new will. These factors, combined, supported a finding of undue influence. The estate would be distributed according to the original will. Diane would receive the house and her designated share. I would receive my designated share. All as my father had intended when he had full capacity. I read the ruling alone in my apartment. And I felt something I hadn't felt since my father died. Relief. Not because of the money. But because his real wishes, the ones he'd expressed when his mind was clear, when he could think and plan and protect himself, had been honored. Diane hadn't won. The manipulation hadn't worked. And the protection clause, the thing she'd forgotten existed, had done exactly what it was designed to do. Diane didn't appeal. Her attorney advised against it. The ruling was solid. The protection clause was clear. The evidence of undue influence was documented. Fighting further would only cost money and yield the same result. The estate was distributed according to the original will. I received the life insurance, half the retirement accounts, and the investment portfolio. Roughly $900,000. Diane received the house, the other half of the retirement accounts, and enough to live comfortably. Also roughly $900,000. Exactly what my father had planned 3 years ago when he'd sat down with his attorney and thought carefully about how to provide for both of us fairly. We never spoke after the ruling. No conversation. No acknowledgement. Just lawyers and documents and legal processes that separated us permanently. I heard later that she'd sold the house. Moved to a different state. Started over somewhere no one knew the story. I didn't follow up. Didn't care where she went or what she did next. Because my focus wasn't on Diane. It was on honoring what my father had actually wanted. And making sure other families knew that protection was possible. That clauses like the one my father had insisted on could work. That planning ahead, being specific, requiring verification, could prevent exactly what Diane had tried to do. Looking back, I understand what happened. My father had been careful. Thoughtful. He'd seen cognitive decline in his own father. Had watched someone he loved be manipulated financially. And he'd taken steps to protect himself. The protection clause wasn't random. It was intentional. Specific. A requirement that any future changes to his will be witnessed by independent people who could verify he understood what he was doing and wasn't being influenced. Diane either didn't know the clause existed or thought it wouldn't matter. She'd convinced my father to go to a new attorney, draft a new will, sign it with the law firm's employees as witnesses. And she'd assumed that would be enough. That possession of the newest document would win. What she didn't account for was that clauses like that are enforceable. That courts take them seriously. That when someone includes specific protection language, it's because they're worried about exactly the situation that occurred. My father had protected himself. Even in decline. Even while being manipulated. The document he'd signed 3 years earlier, when he was healthy and clear-minded, had included a trap. A requirement that couldn't be met if someone tried to change his will through manipulation. And that trap had worked perfectly. I think about the attorney who drafted the new will sometimes. The one who didn't check for prior wills. Didn't ask about medical history. Didn't question why a spouse was in the room providing information during a confidential estate planning session. He'd made assumptions. Trusted that if someone walked into his office and asked for a will, they had the right and capacity to make that request. He'd been lazy. Not malicious. Just insufficiently careful. And that lack of care had almost cost me everything my father had worked 40 years to build. But it had also created the evidence we needed. Because his deposition, his admission that he'd relied on Diane's representations without verification, that he drafted a will based on what she told him my father wanted, proved undue influence. Proved that the document didn't reflect my father's independent judgment. It reflected Diane's manipulation of a man who couldn't fully defend himself anymore. That attorney lost nothing from this. No sanctions. No discipline. Just a failed estate plan that got overturned. But his carelessness had consequences for our family. And I hope, somewhere, he learned to be more careful. To ask harder questions. To require independent verification. To protect vulnerable clients even when they don't know they need protection. 3 years after the trial, I used part of my inheritance to establish something my father would have wanted. A legal clinic that helps families create protected estate plans. We specialize in adding clauses like the one that saved my inheritance. Requirements for capacity verification. Independent witnesses. Language that prevents exactly what Diane did. We work with families where someone has cognitive decline. Where there's a new spouse or partner. Where there's concern about manipulation. Where people want to protect their wishes now so they can't be changed later when they're vulnerable. The clinic is named after my father. Thomas Caldwell Legal Protection Clinic. We've helped over 200 families add protection clauses to their wills. Create safeguards that will activate if someone tries to manipulate them later. Build legal walls around their intentions so that even in decline, even in grief, even when someone they trust tries to take advantage, their real wishes will be honored. I don't know if my father would have imagined this outcome. That his careful planning would save not just me, but hundreds of other families. That the clause he insisted on would become a model for protecting others. But I think he'd be proud. Because it's exactly what he valued. Preparation. Protection. Making sure the people you love are taken care of even when you can't be there to defend them yourself. If you're listening to this and you have aging parents, if someone new has entered their life after loss, if you're worried about manipulation or undue influence, I want you to know something. Protection clauses work. They're not paranoid. They're not insulting. They're just good planning. Talk to your parents about adding language to their wills that requires independent verification for any changes. That mandates capacity evaluations if the will is rewritten within a certain time frame. That requires witnesses who aren't connected to beneficiaries. That makes manipulation harder. Because manipulation relies on secrecy. On isolation. On moving fast before anyone can ask questions. Protection clauses slow that process down. Force verification. Create paper trails. And when someone tries to manipulate, like Diane did, the clause activates. The new will gets challenged. The evidence gets examined. And if the manipulation is real, the courts will see it. My father protected me from across death. From months after he'd lost capacity. Through a document he'd signed when he was healthy and thinking clearly. And that protection, that foresight, made all the difference. Not just financially. Emotionally. Because I know the estate was distributed the way he actually wanted. Not the way someone convinced him to want during his weakest moment. The inheritance I received wasn't just money. It was validation. Proof that my father had thought about me carefully. Had wanted me provided for. Had taken steps to make sure that even if something happened, even if someone tried to rewrite his wishes, the truth would prevail. I've used the money carefully. Paid off my house. Invested for retirement. Started the legal clinic. Built security for myself the way my father built security for me. And I visit his grave every few months. Sit there quietly. Tell him thank you. Thank you for being careful. For insisting on that clause. For protecting me even when you couldn't protect yourself. For loving me enough to plan ahead. Diane tried to erase that planning. Tried to take everything and leave me with a truck. Tried to rewrite history to make herself the only person who mattered. But she forgot one thing. My father had been smarter than she gave him credit for. Had prepared for exactly what she did. And that preparation, that forgotten clause she never saw coming, undid everything. She thought the newest will would win. She thought possession and proximity and being the spouse gave her all the power. She forgot that my father had loved me first. Had planned for me carefully. And had left behind a legal trap that would spring shut the moment someone tried to manipulate him. That trap worked. Perfectly. Exactly as designed. And my father's real wishes, the ones he'd expressed when his mind was whole, prevailed. So here's what I want you to take from this. If you're creating an estate plan, add protection. Specifically. Intentionally. Tell your attorney you want a clause requiring independent verification for future changes. That capacity must be evaluated. That witnesses must be truly independent. That your will can't be rewritten without safeguards. Your attorney should know how to draft this. It's not unusual. It's not paranoid. It's just good planning. Especially if you're worried about cognitive decline. Especially if you've lost a spouse and might be vulnerable to someone new. Especially if you want to make sure your children are protected even if you can't protect them yourself. And if you're the adult child of aging parents, have this conversation now. Before decline. Before crisis. Before someone new appears and starts reshaping their plans. Talk about protection clauses. About independent witnesses. About verification requirements. Make it normal. Make it part of the process. Because once someone is in decline, once manipulation has started, it's exponentially harder to fix. You end up in court like I did. Fighting someone who has proximity and influence and legal documents that look official. And even though I won, even though the protection clause worked, it took 3 months of litigation and $40,000 in legal fees. That protection could have happened without a fight if the clause had been stronger. If my father had specified exactly what independent witness meant. If he'd required a capacity evaluation by a geriatric psychiatrist, not just general witnesses. The clause worked. But it could have worked faster. Better. More completely. And your family deserves that level of protection. If this story resonates with you, if you've watched a parent's estate get manipulated, if you've wondered whether protection clauses actually work, I want to hear from you. Leave a comment below. Tell me where you're listening from. Tell me if you've faced something similar. Because these stories matter. Not just as warnings. But as proof that planning works. that protection clauses aren't just words. That courts will enforce them when the evidence supports it. That you can protect your family even from beyond death if you plan carefully and specifically. Subscribe if you want more stories like this. Stories about family betrayal. About legal protection. About what happens when the careful outlast the manipulative. Because the world is full of Dianes. People who see vulnerability and opportunity. Who move fast and assume no one planned ahead. But it's also full of protection clauses. Legal language that activates when manipulation happens. Requirements that force verification. And when those clauses exist, when they're specific and intentional, they work. My dad rewrote his will. But he forgot one thing. The protection clause in the original will that required independent verification. That one forgotten thing invalidated everything Diane did. And gave me back what my father actually wanted me to have. In the end, his foresight defeated her manipulation. And the clause he'd insisted on 3 years earlier saved everything.